Senator Duenas. If we could do a quick audio check with you.
Good morning, mic check, please.
Perfect. Thank you so much, sir.
Thank you, glad to be here.
Today, the Committee on Health, Land, Justice, and Culture is now called to order. Today's Thursday, February 4, 2021. The time is 11:06 a.m. Notices for this public hearing were disseminated in accordance with the Open Government Law via email to all senators and all main media broadcasting outlets on Thursday, January 28, and again on Tuesday, February 2nd, 2021. The notice was also published in the Guam Daily Post on Thursday, January 28 and Tuesday, February 2nd, 2021. This Zoom meeting is hosted by the legislature's MIS staff, and I thank them for their assistance. The host of this hearing will mute all Zoom participants until called upon by the chair. Individuals testifying shall first be recognized by the chair before speaking and begin by stating your names for the record purposes, please. When called to speak, please ensure, of course, that you are unmuted. So for this morning's hearing, there's only one bill. That's bill number 39-36 COR. It's introduced by myself, Therese Terlaje. It's an act to amend sections 61303A, 61620, 61634, and 61645 of Chapter 61, and to amend sections 66208, 66212A, 66303, 66307, 66406 and 66407 of Chapter 66, all of Title 21 Guam Code annotated relative to enforcing the terms and conditions of conditional use permits, variances, and zone changes. I'd like to thank my colleagues for attending this morning's hearing, beginning with Senator Tony Ada, Senator Terlaje, Senator Joanne Brown, Senator Chris Duenas. Thank you, colleagues, for being here. I'd also like to acknowledge we have present with us today the chairperson of the Guam Land Use Commission, Chairman Anita Borja Enriquez, Chairperson Anita Borja Enriquez, Director Joe Borja of the Department of Land Management, Mr. Edwin Regis, who is the administrator of the Bureau of Statistics and Plans Coastal Management Program. He is also an ARC member. And we have Mr. John Duenas, who is the president of Camacho and Duenas Camacho and Associates. All right, so because I am the sponsor of the bill, I'm just going to give a very brief introduction of it. Bill 39-36 is relative to enforcing the terms and conditions of conditional use permits, variances, and zone changes. The Guam Land Use Commission is tasked with consideration and approval of zone changes, variances, or conditional use applications, among other things. These approvals are sometimes given under specific terms and conditions designed to alleviate harm to the community or to ensure regulatory compliance. These conditions can be difficult to enforce after building permits and occupancy permits are issued, which can result in unfulfilled obligations that adversely impact adjacent properties and the general public. This bill would increase the enforcement of specific terms and conditions by authorizing the Department of Land Management and the Department of Public Works to withhold approval of building permits, occupancy permits, or licenses for noncompliance with the Guam Land Use Commission terms and conditions of approval. Ultimately, the bill would allow revocation of the conditional use permit if the applicant is not in compliance with the terms set forth by the commission. The Guam land use process is in place to ensure projects are safe for the community and the environment. The proposed policy adds teeth and closes some gaps for enforcement of the Guam Land Use Commission and by the Department of Land Management. We will now accept testimony from those on the panel, beginning with Dr. Anita Enriquez, who is the Guam Land Use Commission chairperson. Dr. Enriquez.
Sijus Maasi and Manana Sijus, Madam and Chair, Madam Speaker and Chair Terlaje, members of the committee and members of the 36th Guam Legislature. Thank you for this opportunity to be here. Present with me is Mr. Joseph Borja, who serves not only as Director of the Department of Land Management, but also as Executive Secretary of the GLUC. I do not have a written testimony to present. I do want to state orally that I've read through the bill number 39-36. I understand on behalf of the commission the intent of the language that is being proposed to amend this particular statute, Madam Chair, and I am here to respond to any questions that the members of the committee and yourself may have. But I would like to turn it over to our Executive Secretary, Mr. Borja, for further testimony. Thank you very much.
Thank you very much, Chairperson Enriquez. Mr. Borja, thank you, Director, for being here this morning.
Thank you very much, Madam Speaker. Let me just go through the bill page by page. There's really some very common items there that we put in. And just as a confirmation on the drafting style, the narrative underlying are additions to the law, and the sections of the bill where there's no underline, those are in existing statute. On the first page, which is really, we generally support the bill. Of course, we'd like to see what is the end product of the bill. However, on line 19 on page 2 of the bill, where the Guam Land Use Commission is authorized to revoke approval, we feel that that's a nuclear option. And before it gets to that point, the building official has authority to issue a stop order on that project immediately on verbal. Doesn't even have to be a written order. He can stop it verbally and like that. But the reason why I say that is because the building official, according to statute, is the one that's authorized to enforce the zoning code, the zoning law. And it says that in statute that they are, and there is an appeal process, section 61615, appeals involving administrative enforcement. So in one of them, it's A, to hear and decide appeals where it's alleged that there's an error in refusal of a building permit, certificate of occupancy, or any other order in that case. And I think at that point, when that building official says to the contractor, you've got a problem here because you're not abiding by, by the laws, the regulations, then that certainly gets the attention of the contractor, the builder. And if he has an appeal, if he has something to say about the refusal to be granted the order, that contractor can then take the appeal before the GLUC, or if the GLUC upholds the decision of the building official, then he's not issued a building permit. And there are sanctions for building without a building permit, of course. So that option, I think, is already in there, and it fully recognizes that the building official is the one that that enforces the zoning code. The only other item here then in support, of course, is when notices of actions are approved by the commission, they are recorded with the Department of Land Management, and a copy is given to the ARC committee members, especially the ones, of course, that impose certain conditions on it. I think putting it in statute that it has to be recorded and giving to DPW for the building official to review at the time an application is made. I think that's great. That's good. We do it now, but we don't do it by statute. So making it a requirement by statute, certainly. And I also would include not only DPW, but the other agencies. We do that now, but this statute, of course, would make it a shall requirement to give it to those agencies to make sure that they are informed that the applicant has been informed of these conditions, and that the building official or any other member of ARC, should they be passing in the area and see a project going on and say, well, you know, I didn't approve a 4-story building there. And that was one of the conditions, that they don't build a 4-story or a laundromat in some cases. Then that building official, you know, should be able to take action, stop the work order, issue the work order verbally or in writing. And then if that contractor doesn't go back and fulfill the requirements of the conditions imposed upon him, then certainly the commission will, you know, support that decision by the building official. So there is a due process already for something like that. And that would be basically all for me. One mentioned that the building official is the one in charge of enforcement of the zoning code. And there are items in 61602, the following section, where he gets his authorization on those items. The revocation, it's already there. GLUC revocation is already there in the appeals process in section 61615. And we do agree that recording, transmitting, and informing DPW should be a requirement under the law, rather than just a process that the Department of Land Management uses. And other than that, on line 23, on the second page, where the Director of Land Management shall withhold approval of the endorsement of any building permit, certificate of occupancy. Since the building official is the one that has enforcement powers, I might recommend that you add or replace the Land Management Director with the DPW Director, who is the building official. Of course, he delegates that to the building inspectors to do that, rather than Land Management, because the Director of Department of Public Works will probably be the third one to know of the non-compliance. The first one would be the building inspector. The second one would be the contractor. And the third one is that the Director of DPW should be informed by the building official that they are refusing a endorsement of a permit or an application or a certificate of occupancy, in the sense that they not fulfill the conditions imposed upon them. And again, like I said, on line 19, the revocation is it's a nuclear option. It's a very, very serious thing to revoke that, because if you revoke it, that person, a contractor, if he wants to do it, he's going to have to go and apply through the whole process, which probably, in his opinion, took a long time to do it the first time. So I would go with the appeals process rather than the adding in there the authorization to revoke. That's the end of my testimony, and I'm welcome to any questions.
Thank you, Mr. Borja, Director Borja. I agree with you regarding the nuclear option. It's meant to be a last resort. After, if you will notice in the bill, just for my colleagues, so I've tried to affect the process at 3 stages. And this is at the, of course, the approval stage and anything, prior to the building permit, or if they come to land management for endorsement on the building permit, land management is familiar with the terms and conditions, and they are just a second check in addition to DPW to take a look at the terms and conditions and compliance under the building permit. And then the bill also affects the building permit process and then the certificate of occupancy process. So three different steps for zone changes, variances, and conditional use applications. All right, and then we'll talk more about this later, but yeah, thank you very much, Mr. Director. So we'll hear now from, Director Borja.
Just one other item on, I don't know what page this is. Section 5 under recording.
Yeah.
The notice of actions are always recorded, but I think in this particular case, not only recording, but transmit.
Director Borja, I can't hear you right now.
Yeah. Testing, good.
Okay, Director, we were not able to hear you. If you could, you said you had another.
Yes, just section 5, line 4 concerning recording. Not only make it that it should be recorded at land management, of course it's recorded at land management, but I think make it a point that land management transmits that information directly, the recorded information directly to a Department of Public Works. Otherwise, the only time that Public Works would be seeing that would be when something comes in and they have to come down and record it and see what the issues are. So I think make it also a requirement that should be sent to the Department of Public Works, specifically the building official. That's it. Thank you, Madam Chair.
Thank you very much. We'll now hear from, I'd like to recognize Mr. John Duenas, President of Duenas Camacho and Associates. Mr. Duenas.
Thank you very much, Madam Speaker. I think my concerns are in my written testimony, and there are 2 concerns that I have. The other is that it sort of allows, maybe not, I shouldn't say sort of, it allows the Planning Commission to set conditions for zone change in a zone change. Actually, in the past, and I thought it was a good system, a zone change was permanent. Once a zone change is affected, a property, say, goes from agriculture to commercial, then the uses that are defined under the statute, the uses that are allowed in that zone those are the uses that are allowed. If you want to have a conditional use within that zone, then you have to submit another application and get a conditional use application. I think allowing the Planning Commission or anyone to actually attach additional terms and conditions and covenants to a particular zone, I think it's inappropriate. I believe that the process sets up zone changes as something stable. For example, I just want to give you an example. If a property is rezoned to multifamily and then the commission decides either whimsically or for some reason decides to change the density requirements. I believe now in a multifamily zone, you can have 1 unit per 1,250 square feet. That's the density requirements. But what if the commission says 1 unit for 50,000 square feet, just to be extreme in the example? That to me is out of bounds. I mean, once you have a density requirement in that particular zone, in order to change that, you should go through a conditional use application or a zone variance. Zone variance, yes, you can attach terms and conditions and covenants, and to me that's fine. But once you change a zone, you are subject to the requirements of that zone that is by statute. The other comment that I had, and let me pull up the my marked up copy here, is the part under conditional use. And then there's a statement in there that was inserted that says, no use shall be permitted which is inconsistent or incompatible with the uses of adjacent property, nor which would otherwise be detrimental to the public. I think the part about detrimental to the public is already in the context of that is already in the preceding provisions, but the no use shall be permitted. What if the adjacent property has an illegal use? I mean, it doesn't address that, right? I mean, you sort of presume that, but you can't be submitting presumptions in when you're creating statute. I don't think that sentence is particularly necessary. So those are the only two comments I had. I agree with Director Borja that this is the intent is really good. We see a lot of examples out there of conditional uses that are being violated, or at least or zone variances that are being violated. I think enforcing those will probably set a good example. But I think that these changes should not be extended to zone change. If a zone is being violated, the first stop is obviously their licensing requirements. You're required to prove that whatever use you're proposing is consistent with that zone. If you're going to build something, the setbacks are set by statute. If you wanted to change the setbacks, you have to go in for a zone variance. That is when you can attach terms and conditions and covenants. That is all, Madam Speaker.
I appreciate that. I appreciate your testimony very much. It's very well taken. Will you be able to stay online for one more testimony and then some questions, Mr. Duenas?
Yes.
All right,
yes.
Thank you. Okay, so we will hear now from Mr. Edwin Regis from the Bureau of Statistics and Planned Coastal Management Program. He's the administrator. Thank you, Mr. Regis, for being here.
Happy day, Madam Speaker and honorable members of the 36th Guam Legislature. Thank you for the opportunity to provide a testimony on this bill. I'm here today to speak of the intentions of the bill, and I'm hoping that as the legal mechanisms kind of work through the process at the end result, it does conclude with greater enforcement capabilities of the Guam Land Use Commission. As you know, the Guam Coastal Management Program were responsible for various land use planning for the Bureau of Stats and Plans, but also provide technical review as part of our application review committee responsibilities, and we're hopeful that that review can provide insight and information useful to the Guam Land Use Commission to help them discharge their authorities and understand the implications of the decisions that are before, of the matters that are before them. Typical of the ARC reviews, we usually look for various constraints and considerations, whether they're land use or environmental or built. But a lot of the conditions that we place on the applications or the conditions that we request to be placed on the approval is related to flooding and stormwater. So we have we refer to the Guam Soil and Erosion Sediment Regulation, we refer to the Guam CNMI Stormwater Management Manual, and we encourage a lot of time for the applicant to implement green infrastructure or low impact development or other tenets of smart planning that really tries to preserve as much as the natural charm as possible. We know that things definitely, in development, there is the process of, the whole architect, engineering, design, construction, that whole gamut. But if at some point we can get there early enough and instill these tenets of smart growth and smart development, we're hoping that can then shape the overall design plan. And so some of those ideas and standards we try to incorporate into our position statements. And if I can, and the other conditions that we request to be put on are for matters involving access to the seashore. And to put things into context for this particular hearing, if I can ask the AV to pull up my 2 slides, please. Okay, so the first picture here, this was taken last week, and this is a facility down in Gun Beach area. I wasn't able to do the modeling and the mapping for this map, but I'm very confident that the structure is within the Seashore Reserve. As you know, the Seashore Reserve is, the boundary is from the mean high water mark, which is 1.9 feet in elevation, and 10 meters 10 meters inward, so that's about 33 feet. It's pretty safe to say that this structure does fall within the Seashore Reserve, which is overseen by the Territorial Seashore, basically the Guam Land Use Commission, which also serves as the Territorial Seashore Protection Commission. So if a variance or conditional use was put in place, we would be able to look at the regulations that we stipulated that would be in there, such as the compliance with stormwater management and other environmentally based and stormwater management requirements, to go back to the structure and say, okay, here there's some clear violations, but because there are you know, trying to re-engage the Territorial Seashore Protection Commission has been difficult in the past. We really don't have any clear mechanism to come back and to try to resolve this through the Territorial Seashore Protection Commission. And may I also point out that the particular boundary in which this planning area falls under, and also the regulatory oversight in 21 GCA Chapter 63 and 21 GCA Chapter 64, I believe, refers to the Territorial Seashore, the Territorial Planning Commission, which is now the Guam Land Use Commission. So the only mechanisms to enforce this in terms of shoreline area and encroachment into the Seashore Reserve is the commission itself. In the past, we had written a letter to the former chairperson of the commission and had no response in terms of some of the issues that we had brought up. And so we're hopeful that as this bill becomes, it strengthens the planning controls, that mechanism for enforcement will be much more clear to not only to my division, but also the regulatory agencies of the government of Guam. If I can ask for the next slide, please. Other issues that we have are public access, and anytime there is development by the shoreline, one of the conditions that we put in, regardless of if it's a zone change or a variance, is this protection, public access protection. And again, you know, once the decision is made, we have a hard time going back, and when we see fences being put up in violations, we have sent the letter in the past, and unfortunately nothing was taken. So I think this speaks to the need for some clarity and some stronger language in which we can work through the mechanisms for the Territorial Seashore Protection Act, as well as the access to territorial beaches, which links up to the Guam Land Use Commission, and be able to get a resolve through that mechanism. We understand that, of course, the building official deals with permitting, and then you have the whole business licensing and all that other ways that we regulate you know, businesses and make sure that they're complying with things. But what I want to emphasize is that there is these laws on the books, 21 GCA 63 through 65, that provide that linkage to the Guam Land Use Commission, and hoping to strengthen that. And that's my presentation, and that's my testimony for this hearing. And I'll stand by for questions.
Thank you very much, Mr. Agent, for your testimony. All right, for the record, we've also received written testimony, and so Mr. Duenas' testimony has been submitted in writing and provided to my colleagues. We've also received written testimony from Adrian Gogui from Save Southern Guam in support of the bill. We received a fiscal impact note from the Bureau of Budget Management and Research. Their summary pretty much is that the bill is administrative in nature and poses no fiscal impact upon any of the funds of the government of Guam. And so that being said, I'm going to move on to the questions. And if I could just ask a couple, Director Borja, does the, can you just state for the record what current processes the Department of Land Management be involved regarding conditions or enforcing compliance with conditions that are set by the Guam Land Use Commission?
Conditions, like I said, the enforcement of the building code, the zoning code is up to the building official at DPW. We don't do any by statute, any inspections. The only inspections we conduct are concerning the temporary workers housing application. When they come in for renewal, we do an inspection. It's not required by law, but for the case planner, they feel comfortable going out at the time of renewal to see if the conditions were made on those applications or those notices of actions where conditions were imposed upon them. But no, we do not do any inspections on that. Once it gets out of the Guam Land Use Commission, the enforcement of those conditions is up to the building official. We do get complaints about activities that may not seem to be within the zone. And most of those, of course, we do attend and review. But a lot of those are conditional use that were previously granted. And then some of them were even without public hearing back in the 80s. And those conditions, I don't know if we can make this law retroactive to those applications. I think by and large, as Mr. Duena said, there are violations out there, and those violations should be uncovered or should be addressed to the building official.
All right. Does the Department of Land Management have a role in the building permit process?
Yes, we do. We sign off on those building permits and business licenses, but only relative as to zoning. Whether the application for a particular project is in the correct zone that they are doing that. Yeah. So that is the process that we have. We're usually the second agency that reviews that application. The first one being DPW, where they issue and the application is made for that building permit there. And the other agency that is the initial agency is Revenue and Tax for those business licenses. After those two agencies accept the application, at that point, land management steps in and says correct zoning or incorrect zoning, and approve or disapprove based on those merits.
Okay, well, that's what I'm trying to do by this bill. It's because during the building permit process, land management does have review of the, or a say in the building permit. That's what I meant by they would review at that point whether it's in compliance with the conditions that had been set, because land management is familiar with those, and just as an assistance to the Department of Public Works, that they could help to, remind them that there were conditions, or just to review. It's like a double check to review that there were conditions and that they can be enforced at that time, or the developers reminded. Yeah, just for the record, I did invite the Department of Public Works to this hearing, and I don't know what to say, but I guess we'll have to follow up with them. But yeah, that's so that's part of it. Yeah, Director, is that it's kind of like at that point where you are making your do you have a similar role in the certificate of occupancy process?
I don't believe so.
Okay. All right.
But I will check, Madam Speaker, to be absolutely sure on the certificate of occupancy.
All right. And then, Director, as to Mr. Duenas' point regarding zoning, even I was not sure whether conditions had ever been set on zoning, but could you tell us whether conditions are ever set, terms and conditions are ever set when they rezone a property, when the Guam Land Use Commission has rezoned a property, or Chairperson Enriquez, and either of you?
That in one case it is in limited commercial. conditions are actually stipulated. And usually it's an application, for example, to open up a commercial facility, but the municipal planning council, the community doesn't want to open up to full commercial, like 24 hour operations, vaping bars, things like that, lounges, nightclubs, usually in certain areas and like that. So there is a zoning where conditions are improved, and that's in the limited commercial thing, which is actually relatively new for the commission to handle. I think the first a limited zone, a limited commercial application was a couple of years ago. Previous to that, although it was on the books, people didn't apply to that. But I think now the public and the consultants have found that there is a way to get rezoned commercial and still address the concerns of the community, the municipality, which is through that limited commercial zoning.
All right. So you're saying if it's a limited commercial zone, that you've seen the Guam Land Use Commission put terms and conditions. And maybe if you could send some examples of those notice of action or rezone with the conditions for that, I can also share that with my colleagues. I would just like to look at it myself as well.
I would also agree with John Duenas that once you zone these things, they're permanent. And even there was a question about conditional uses. Once you grant a conditional use permit and they're following the conditions, that at least council has advised that those are forever, those are permanent on there, So,
I haven't tried to put anything in the bill that would allow to rezone, but if there were conditions as you've described in limited commercial zones, then I'd like to take a look at that. Otherwise, yeah, if I agree that zoning, once it's done, is permanent. However, the conditional use, yes, that was intended to be a last resort that, after, building permit, because some of the conditions, is it true that some of these conditions, they are meant to last, for the duration of that specific use. For example, if you're supposed to comply with flooding requirements, it has to last the entire time. So after the building permit or the building official tries to enforce and it's not able, they appeal and they lose and they still do not comply. That's what my intent was, that's a kind of last resort, that then, further enforcement that then this conditional use should not be allowed anymore if they are absolutely unable or unwilling to comply. My apologies. I'd like to recognize the presence of Vice Chairperson Sabina Perez. Thank you, Senator Sabina Perez. Okay, and this, as to the second point, sorry. Here. Okay, and so Mr. Duenas, yes, as to your second point, so the first point, I agree with you, except for that limited commercial use, I'm going to check with the director on that. But as to the second point, I also agree with you. This language I actually copied from another statute that was talking about when you split a zone on the same lot. And so they wanted it to make sure it was compatible with the adjacent lot, but I have no problem removing that sentence because I think you're right. It is taken care of during the regulatory process, all of these concerns. All right, I'm going to, Mr. Duenas, please. Yes.
I just wanted to offer some comments to what Edwin was testifying to. With regard to the beach, which is down at Gun Beach, the fact that it's encroaching into the seashore protection zone or into the seashore reserve should have been caught at the building permit phase. I mean, obviously, if they misrepresented the location of that building in their building permits and then build it where they shouldn't have, the building official can go down there and cite a violation, and then probably in the end require the building be taken down or cut back to the to allow the reserve to be unimpeded. Regarding storm drainage, the same thing applies. When you review a building permit, you have to submit storm drainage plans, and if those plans are being violated, then you can issue a notice of violation. I think EPA could do that too, issue notices of violation. I don't think, Edwin, that you can allow that thing to continue. We don't need any additional laws. I think there are enough teeth already in our laws where you can actually force the owner of that structure to get out of the seashore reserve. The second one, the fact that they put a gate there, I'm not sure about that. I don't know who put the gate there. It could be AT&T. AT&T has perpetual easement for their cables, and it goes all the way down to the shoreline. But again, those things should require some kind of a permit. And during that permit review, then you can review whether you're impeding public access to the beach. So I think there are already remedies in there, Edwin, that you can lean on either Department of Public Works, the building official, or call the Attorney General's attention to these violations. I think there's something that you could do. However, if conditions that you recommend aren't adopted by the Planning Commission and it doesn't find its way into the notice of action, then I guess there's nothing you can do. That's all, Madam Speaker.
Thank you. Yes, and I note that there are conditions that are set by law, such as access, and there are conditions that are adopted through the Guam Land Use Commission process, kind of added on. All right, I'm going to open it up now to, sorry, yes, Mr. Regis?
So I just want to, just in response to John, I just want to point out that while I do acknowledge that there are the development controls and permitting controls in place at DPW that relate to the permitting phase and the oversight phase, the statutes that I mentioned specifically refer to the Guam Land Use Commission's function as a regulatory involvement. So in this case, we are following due process and working our way up to the Guam Land Use Commission in both attempts for the Gun Beach closure that was met with no resolve. It fell on deaf ears. There was no action taken. So there certainly is some work that needs to be done. In terms of the flooding regulations, there is a lot of work going on with the Silver Jackets program that we are spearheading that also involves the Army Corps of Engineers, EPA, DLM, and other regulatory folks. And flooding is confusing. There's work that needs to be done to improve how we manage storm drainage. You mentioned EPA. Well, EPA doesn't get involved unless the actual water is contaminated. And then there's a whole, source of the water. Does it when it leaves the property, it flows onto government easement. Then government easement's now responsible for it. Then it flows downhill, and then eventually it works its way down to Tumon, which cuts this channel right through a once pristine beach, which there's no natural way for this to restore itself other than maybe waiting 100 years for the sand to come back. That's all, Madam Speaker.
All right, Mr. Regis, are you suggesting that we review how GLUC's role in enforcement of those Seashore Protection Act provisions, or whether they're able to or not, and or whether DPW or some other entity can also assist in enforcement of those provisions? perhaps not in this bill, but in another bill. But yeah, I understand what you're trying to say. It's that enforcement part. These are requirements that exist, and right now they're tagged to the Guam Land Use Commission to enforce. Is that right?
That's right. I certainly agree with John that there is the enforcement mechanisms within the building officials that maybe could be applied a little bit more aggressively. But in terms of the regulatory functions in those three provisions that I mentioned, I think it is worth an investigation.
All right. Okay. Appreciate that. Thank you very much. All right. I'm going to open it up to my colleagues right now. Senator Ada, you're recognized.
Thank you, Madam Speaker. Just for Director Borja, this question's for you, sir. Director Borja, can you hear me?
Yes, I can.
Oh, okay. Thank you, sir. No, I heard you earlier in your testimony about the, on page 2, line 19, the Guam Land Use Commission is authorized to revoke approval of conditional use for any failure to conform to the terms and conditions or covenants of the conditional use set by the Guam Land Use Commission in approving the conditional use permit pursuant to this chapter. So you're saying that we don't need that section there, as there already a process for such a revocation of a permit, right?
I believe there are in section 61615.
Right. Yeah. Okay. So yeah, I just wanted to clarify because I think you were, I know you were saying we didn't need that section in there, and I'm not sure if Madam Speaker was alluding to that we'll go ahead and take it out or just keep it in there as the nuclear option. But so you're saying that we don't need it in there?
I've said yes, but I think that process is covered by section 61615.
Okay, that's it. I just wanted clarification on that. That's the only question I have, Madam Speaker. Thank you. Thank you, Director Borja.
Thank you.
Thank you, Senator Ada. Senator Taitigui, you are recognized.
Just mostly, Madam Speaker, for the opportunity. And thank you to everyone that's here. It's always good to see you, Edwin. I will recommend a song next time for you. And of course, Anita Borja, Chairwoman, thank you for being here today as well. And Director Borja. John, I'm hoping you'll be at the 2 o'clock public hearing on the ARC bill. So looking forward to your testimony on that one as well. So Mr. Borja, I do have a question with respect to the terms and conditions set forth by the Guam Land Use Commission. Does a developer have a certain amount of time after receiving approval from the Guam Land Use Commission to complete a project?
I believe there is a 1 year. If you don't turn dirt in 1 year, then you've got to come back and give a report on it.
Okay, 1 year. So if a developer, for an example, received approval for a project with terms and conditions in, say, 2021, but never finished or even started the project after 10 years, is it appropriate for the developer to have the right to work on the project in 2031 with the same terms and conditions?
Well, those, zoning, rezoning, those are permanent issues. And that's something that the legislature may want to look out. Usually, community outcry and utility agency outcry usually puts those on hold. But there are some conditional use permits that were granted in the 80s that have not been implemented. Construction hasn't started, anything of the sort. Prime example is the Serena Hotel over there in Agat, right across the marina. I think it was called the Serena Hotel. And approval had been given for a hotel down there, I believe, in the 80s. And of course, the surrounding area has changed tremendously since then. And, the infrastructure has changed so much at that time. But generally, zone changes, conditional use permits are permanent.
I see. Okay, well, thank you for that. And And yes, I agree with you too as well on that section from taking the authority from the Department of Land Management to DPW for the building permit. I saw that you mentioned that, and yeah, I saw that as well too. So it makes sense, you know, because they're the ones issuing out the permit. So other than that, I appreciate your time and those who are here testifying on that. And Edwin, you know, if you need any help to go after those guys down at the beach, let me know, friend. Okay. Okay. I think it's important too, Edwin. Thank you for looking into that. Bye-bye. Thank you.
Thank you, Senator Taitegui. Senator Brown, you're recognized.
Thank you very much, Madam Speaker and Chairwoman, and certainly thank you to everyone who's here to participate and testify with regards to this bill. You know, I share some of the concerns, and I just want to provide for disclosure purposes. I probably have to resign my membership, but I'm one of the founding members of Save Southern Guam, and certainly we had issues with regards to the construction of a high-rise condominium / what was also intended to be a hotel in Pago Bay. And some of the frustrations from a public standpoint and a resident standpoint that we had to deal with regards to the commission and the ability of the public to have an input. And then also because our group was very aggressive in following up with regards to compliance on that particular project, we found that as a result of that, there were a number of conditions, and it's not uncommon in my 30 plus now years of experience, certainly since I was at Guam EPA dealing with conditional use that have been authorized by the Guam Land Use Commission, only to find out that there's no real aggressive steps being taken to ensure that after a zone change has been authorized or conditional use has been authorized, to ensure that the conditions set by the commission have been enforced. One of the issues I know that we raised with considerable concern, because we have the adjacent Pago Bay residential development that, my goodness, I think the groundwork for that was done 10 to 12 years ago. And yet we still don't know today, unless anyone has the information, whether or not there has been the proper reinterment of the remains, the ancestral remains that were extracted from that property. And as members of the community, we could never get an answer from the developer if that has since happened, nor could we get an answer from land management, to my knowledge, as to whether that particular reinterment ever occurred, and those were part of the conditions. So what I have found is that there is inconsistent and lack of follow through with regards to ensuring that when conditions are set by the commission on the approval of a variance or a zone change for the construction, particularly with regards to major development projects, the follow through and insurance of compliance is very, very weak. And I don't know if that's something, Director Borja, we need to look at specifically with regards to land management, because I doubt the building and, you know, the head of the building inspection at DPW is thinking about what these compliance lists are, or looking at it or following up on it. And as time goes on, you end up finding out that there's not that compliance. I'll give you a very good project that I was so orientated to, was the construction of Ladera Towers. At the time, residents in that area, we're talking GCC, UOG, and a number of people that lived in apartment complexes and a number of residential homes in a very established part of the village. And when that particular condo project was constructed, it was constructed on barely a 2-inch, or authorized for occupancy on barely a 2-inch water line. It met none of the compliances for the sewer upgrades that were required. It met none of the requirements that land management had issued for them to construct 2 additional water wells to be able to offset what was already, in that circumstance, tremendous low water pressure and brown water that residents in that area were experiencing coming out of their tap. And so I have yet to see, and coming back years later dealing with the Pago Bay project, I don't see that level of aggressiveness. I don't know if it's because land management doesn't have the resources, land management doesn't have the teeth, or is nobody there going back to verify to make sure that these developers are complying. There's a tendency with Department of Land Management historically with the commission to try to condition a project to meet requirements, whether it's tangible, viable or not. I don't even think they look at that. Sometimes it's just put in there to make sure a project gets approved, and then years down the road is their follow-up. And that should not be the case. I don't think any existing community here in this island, or any village in this island, or any resident should see a decrease in their quality of life because a construction project has been approved. And yet, if there are requirements put in place to address upgrade to water, sewer, transportation because of traffic related issues or anything of that nature to make things work for everyone involved, that follow through doesn't happen. So I appreciate it, Madam Chair. I think this bill is a very important step. But again, I think we need to see how we can further strengthen that process to ensure that developers, when they make these commitments in order to get the approval from the government and approval from the community, that there's follow through, that there's enforcement, that there's insurance, that the file gets closed, so to speak, and that that particular project meets and addresses whatever those requirements are. So if I could ask that question of the Director of Land Management, Mr. Borja, if he could provide a response to that.
About what you said about the follow-up from land management to see if these conditions are being implemented. No, that what you stated is true. Land management doesn't have the capability right now, and it's not the thief. It's basically, well, the thief is in the building official. If land management was to do these inspections, follow-up inspections, right now we only have 4 planners. So that's the other side of the equation that you mentioned. Is that we only have 4 planners. One of them is on the job 1 week, a new planner. And our planning division actually has our 2 senior planners on the retirement watch. They're eligible for retirement. So if in order to do that, we still need to build capacity. You could put something in the law requiring an application, rather a project to be inspected maybe 1 year after the condition has been given, after the approval has been given. And the only thing here that I would make sure to watch out for is that these people do not come to, the applicants themselves don't come to the building permit section or the business license section to see if they've been complying. Because at that point, we can't make a determination right then and there. So if you want to put something in there, a regular inspection to see if they're adhering to that condition, to those conditions, certainly it's in there. But, you know, I'd like to be able to follow that up with bill adding and funding another planner to basically review that section.
I appreciate your response, Mr. Borja, but then it still doesn't give me any comfort. The fact that the Land Use Commission goes through all these efforts and hurdles to review an application, and all certainly the time that applicants and investors are putting in place to get such approvals, all the effort put into writing down list of conditions, and then there's no way to enforce them or no way to ensure that the community interest is protected. What is the objective here? And this is nothing that's changed. I'm talking over the last 32 years. Just from firsthand experience of seeing how this process operates. I mean, if you can put a multi-million-dollar project in place, but have no way of ensuring consistent compliance with regards to conditions that are set by the government, assuming that those conditions are set in the interests of the community, then I think we have a problem here. I think we have a significant problem that's been sitting for some time. I mean, I see complaints and certainly concerns about our natural resources being adversely affected with military construction on Guam, but I do not see the same issue of concern when it's the very same degree of ancestral resources and ancestral remains that are not taken into consideration and given proper and due respect and proper reburial as we would expect of anyone else. And yet we sit and do nothing about it. I don't think that's acceptable. I don't think it has to be residents complaining or bringing up these issues to the government for the government to enforce conditions that it has set in order to authorize a project. So I think we really need to look at this, because it's pointless for the Land Use Commission to continue to operate, review applications, set conditions when there is no mechanism in place to ensure that there's compliance with those conditions. Having worked at DPW, I know that the building head of building inspections, I'm sure, is very, very busy. I'm sure they're not going to be worried to be looking down the list of conditions set by the Department of Land Management. Department of Land Management, if it's been given the authority to set these conditions, needs to have a mechanism in place and a way to ensure that it can enforce its conditions so that these projects are compliant. It's very hard after a project is built. And once it's built, like in the case of Ladera, even though I know I'm stretching back many, many years, but it's such a classic example. You look at the construction of that particular facility that's totally inconsistent in size, and capacity than any other building around it, but yet it was authorized. It had the capacity of up to 1,000 people for occupancy. And yet that project was constructed without a building permit to begin with. That took enforcement action. The issue with regards to the water upgrade that was required was not addressed until many, many, many years later, and many public issues being brought up before that company finally, I believe they actually ended up providing the money, even though they were required to upgrade and build the water wells for that project. They ended up through pressure having to pay the money to depart to the Guam Waterworks Authority, so the Guam Waterworks Authority could identify and site and construct those water wells. The upgrade, imagine the sewer upgrade that would be needed on BPM Road, and yet you already had areas like the University of Guam, the Guam Community College. You have a number of apartment units that are there where people couldn't get water to the second or third floor. That's not the kind of development that's in the interest of the project developers and the future occupants of those type of facilities. And it's not in the interest of the community, because we're not bridging over to ensure that when we have to accommodate and address these concerns to deal, particularly with larger projects, who's left at the short end? Probably both sides ultimately, but more importantly, my interest is the community interest. And I just see our people left at the short end of the stick. I mean, the fact that the Pago Bay project was allowed to move forward, was permitted. Of course, you have individual homeowners there that purchase a lot and build their homes, but they did not address the reburial within a timely manner of those ancestral remains. They tried to attach it to this new high-rise proposal that came up a few years ago with a adjacent property that they sold to a new investor to build this particular condo / hotel project. Fortunately, it took almost 2 years and our consistent involvement before the Land Use Commission finally pulled back on that particular application. But that is not how it should be. That is not what our community should be subjected to. So I think maybe Director Bora, if there's a way collectively, if we can look at seeing what recommendations can come forth to actually give land management a greater say, because you're setting the conditions through your commission. You're setting these conditions, but you almost have no way of enforcing your conditions. And those conditions consistently over the last, at least like I said, in my experience since 1990, are not being enforced. So what can be done besides giving you another planner? What can be done to take action? Or should there be penalties and fines put in place if a developer makes commitments to do these things? Because more than likely, they're all infrastructure upgrades or to mitigate what has occurred, like ancestral remains being reinterred. What can be done in your mind to help address this process so that we can all move forward collectively with a project that's being given approval?
Well, in the bill, like I said, or in the law, it's the building official that enforces this. If you want land management to enforce or at least review those conditions, you can put into statute timely, regular routine inspections to make sure that they are doing what they're supposed to do with the conditions. We do that with the temporary workers housing, but yet it's not mandated. So I think that's one thing that you can do is to mandate it. But I think, as Mr. Duane has, stated that those two examples that Mr. Ray just brought up, they should have been caught at the building permit process. And this bill, wants to make sure that the Department of Public Works receives those conditions so that in review of any building permit, those can be addressed by the building official to look at that. Because if the building official doesn't know what conditions are applied to that particular lot or that particular project, then certainly he won't be able to enforce it. So the bill, I think, is a very good start because it requires, although we do send to all the ARC members the conditions and that were approved, the notice of action, I think this just further reinforces that it should go there. If you want land management, since it was the Land Use Commission, which the Department of Land Management provides the support to it, if you want us to do it, then certainly we would need manpower, we would need the tools to do it, by a change in the law to do it, or in addition to the law to require land management to do those conditions, to review those conditions.
Thank you very much, Ms. Rohr. Sorry, Madam Chair, I'm so passionate about this issue, having been on the receiving end with regards to this process. But I just feel very much, Mr. Borja, somebody needs to be overseeing this once it's authorized. Someone needs to be going back in the file, because some of these projects, they're conditioned to be able to meet the conditions. It might happen over a period of time after the project's in place. There might have been some condition put that follow-up needs to be done to ensure that they implement those conditions fully, and to the point that all the check marks are made and that everyone is signing off on it, and then we're able to move forward, with that project. But that hasn't been done. And so I very much think somebody in the government needs to be overlooking this project to make sure that those conditions are met. And then I also wanted to ask, if I get Mr. Regis from Bureau of Planning, are you challenged or getting the impression, or what is your experience with regards to ensuring your sister agencies are able to respond when you do see a violation that maybe falls under certainly Bureau of Planning in your coastal zone, but the authority to address enforcement maybe in Guam EPA or maybe at DPW? What is the response to requests coming out of your bureau to address those concerns and maybe address joint enforcement or follow-up or whatever the case may be that's needed on your end to ensure compliance with what falls under your jurisdiction?
So yeah, thank you for the question. For the two requests that we put in for the public access violations, that went unanswered. So in terms of the Bureau's broad coordination authorities under our central planning mandates, we address the coordination aspect through various kind of engagement situations where we bring people together. We do it through the Silver Jackets program, where we look at a specific problem such as flooding and the issues that subdevelopment that development has on flooding, whether it's the issues with the subdivision law, or whether it's the parental subdivision, how this incremental and cumulative growth that happens very slowly, how that contributes to this larger change in affecting the landscape in terms of impervious development. So we have that coordination piece that works towards working with government agencies through this long-term planning process. But what I would proffer to this group, and thank you, Senator Brown, for being so passionate, is perhaps maybe there could be language added to the bill which requires the chairperson of the Guam Land Use Commission to consider reports of violation that are brought to the commission and to take action on it. What this will do is it'll allow my letter that went to the prior chair a legal mechanism to be recognized and therefore have a timeline to be acted on. So that could be one way of maybe other additional capacity in addition to Joe's shop, where we can come in through our planning mandates and be able to convey those issues to the Guam Land Use Commission directly, or whether it's constituents coming to us, and we can convey that up after, of course, we do our investigation. That will be done through various mapping exercise, mapping and modeling. It'll be done through visual inspections. It'll be done through various tool sets that we have available to us as planners to make the case that there is a coastal effect based on that development.
Madam Chair, I just have one other comment. I know I've taken up a lot of time, but I just have one other comment because that issue was brought up with regards to zone changes that perhaps were made years ago, and then the project never got off the ground. And most of these zone changes are requested because they're actually looking at constructing a particular project. I don't know if it should have a Cinderella clause, and maybe we should look that, it's conditional for a zone change, and it has a time frame, be it 3 years, 4 years, or 5 years. If by that time, a developer has not executed that project, has not started groundbreaking or construction, perhaps, at midnight on a certain day, it just, the pumpkin disappears and the zone change approval disappears. That way we don't end up in a situation where, we're approving something today and they don't build it for 20 years and it's already authorized, and yet the surrounding community, the infrastructure issues may have changed. And I think that sort of puts the onus on a developer, if they're serious about building a project, that they do so within a specified timeline, unless they can come back and demonstrate to the commission as to why, or, whatever the conditions of, like in the past, it's been because they've not been able to get the workers, on Guam to do the construction work. But there's got to be a mechanism put in place so that we don't do these approvals and then the property and projects sit, and then 20, 30 years, people have built up around, and then they get surprised, and the landscape has changed so much. So I just think that's something we can dialogue on and probably also look into as well. Thank you very much, Madam Speaker, for the opportunity to ask questions and comment on this particular bill and the issues it's brought forth.
Thank you, Senator Brown. Yes, and I want to thank Director Borff and Mr. Rages for their responses. And I do want to state the last point is not covered in the bill. Cinderella clause, as you called it, that's not covered in this bill. But the other parts, it's like we are trying by this bill to increase enforcement beyond the Department of Public Works building permit and occupancy permit stages, where when they come to Department of Land Management for, signing off on those permits as well, that they are both obligated to review the terms and conditions, that they both have notice of the terms and conditions, and they are both kind of mandated by this statute to review the terms and conditions, make sure compliance. Now, that doesn't ensure compliance for years after the occupancy permit is issued. That's the, of course, Mr. Duane has described, building, the DPW director has that authority by statute to always go in and inspect, make sure they are in compliance with their building permit, their occupancy permit. But hence the, what did we call it earlier, Senator Ada and Mr. Duane, is the nuclear option, I guess the Director Laura referred to it. That's just a second protection in case we have a director that's not enforcing things. And I was hoping, as you described, that we could establish a process where the Guam Land Use Commission can re-examine, particularly for conditional use applications, not for rezoning, or anything else, but conditional use application, they examine those conditions. But all right, we'll move on to Senator Chris Duenas and then Senator Perez. Senator Duenas.
Thank you, Madam Chair. I have no questions. This has been an excellent dialogue from this distinguished panel, and I just look forward to working with you in the committee for the proposed changes and whatever else may happen on the floor. So thank you to this very distinguished panel. Excellent presentation. Thank you, Madam Chair.
Thank you, Senator Duenas. Vice Chair Senator Sabina Perez, you're recognized.
Thank you, Madam Speaker, and thank you for this measure. I think this is long overdue in regards to conditional permits. I know that in the past, when I asked a question, who oversees the conditional permits, and the answer was pretty much there wasn't anybody really assigned to this. So I do appreciate this measure. And I do share a lot of the concerns of my colleagues in regards to enforcement actions. And I know this is a good first step, and looking forward to more dialogue, with BSP, Department of Land Management. Yeah, and I know we have the application review committee, which deals with zone changes, variances. And I was wondering, perhaps maybe this could be a different discussion, but expanding that, the purview of the application review committee to apply it towards conditional use. Is that something that is recommended or feasible? So I don't know, this question can go to Edwin Rages.
So I'll answer this question in terms of the lens of our ARC membership. And right now, my understanding is that our function is to serve as this technical review body, and then to provide, the various insights of an action of a particular development to a body which is above us, which is the Guam Land Use Commission, and to ensure that we articulate any issues that we have, and that's kind of it. I think if we were to add maybe an additional function which will allow us to convene to review a violation and make a determination among this body whether or not a violation does exist, we would have to have some other mechanism to do something with that determination from our ARC, whether that's elevated up to the GLUC or whether we're empowered to take stronger action ourselves. But that mechanism is not in statute.
Okay, and then the other thing is the land use policies.
Sorry,
I
Senator,
know,
could we let Mr. John Duenas also answer that question, if you don't mind?
okay, surely.
Any application for GLUC action has to go to the Agency Review Committee. And so, yes, conditional use applications go through the Agency Review Committee. But just a little bit of history. Way back when I was at the Department of Public Works back in the 70s, we had a committee called the Subdivision and Development Review Committee. The ARC is sort of an outgrowth of that. But I want to tell you what the problem is with ARC right now. And I think this afternoon, Senator Taitegui, you mentioned about having a hearing on the ARC, an ARC bill, that when I was participating, and I was the chief engineer of public works, I attended the meetings. If you look at the ARC now, there might be some representatives that are actually, I would say, occupy the upper echelon of management in those agencies. But if you look at the representatives at the ARC now, many of them are just delegates. They're just people that have the time or are designated to go attend an ARC meeting. You don't receive high-level thought, comments, considerations from the agencies. All you end up having is somebody reading a list of requirements that they want to see, rather than actually telling you what it is that you need to do. So if there's any teeth to be put on the ARC, I think there should be a requirement that that higher level management employees of that agency attend the commission in person. For example, the chief engineer of public works ought to be attending these agency review committee meetings, rather than just somebody who had the time to do it, because then you can get more insightful comments. And then the conditions that come out of that deliberation would be something that, well thought out. That's my comment. The other thing that I wanted to point out is that there are at least two zoning zones that allow conditions to be placed. One of them is the Planned Development District. You can pretty much dictate what you want in the Planned Development District. I'm talking about the commission. You can put conditions. There are open space requirements. So there's a lot of leeway for government to actually dictate how a development should take place. The other is the hotel zone. If for a hotel zone, you really have to make a presentation, and there are sunset clauses. I believe in a planned development district, if you don't turn over dirt or start your development within a year or within some specified time frame, then the planned development suspended. So yes, but we're talking about commercial, multifamily, R1, or single family residential. Those are pretty much static zones that should remain the way they are. Thank you.
Thank you so much. I guess a question for the land use policies. So I guess first of all, for these conditional permits, is there a review of whether it complies with the land use policies? Is that review in place?
We do conduct our reviews against the land use policies, and the two policies that we reference are the the Cabalas and Plano Paraguajan, and then the Northern Guam Central Land Use Plan.
Okay, and should that be a part of what Department of Land Management or, for these conditional permits, Should that be included as part of their review as well, or is it already integrated into the process?
I think that because we are in attendance, that we represent the land use policies at that forum. So it wouldn't maybe be the best fit if the other agency would be required to have this additional lens. Although I'm certainly in favor of expanding the rigor of review. And so, you know, it would have benefit, but it may be duplicative.
Okay. Oh yeah, do we have an inventory of, oh, sorry, Mr. Duenas, you had your hand up, you wanted to comment?
Yes, I wanted to say that if you look at the zones, there are permitted uses which allow you to use without having to go to the planning commission or getting any kind of permit other than development permits, building permits. But there are conditional uses that are allowed in those zones. You can apply for a conditional use in that zone. And there are incompatible uses. For example, if you had a multifamily residential, having a heavy industrial use is not permitted. But there are conditional uses in a multifamily residential zone, and you can apply for that conditional use. And the conditional use goes through the ARC, goes to land management. The land management actually conducts a pretty thorough review. I'm quite familiar with the planners down at land management. I think some of them have retired already. Unfortunately, Director Bora, you don't have that resource any longer. But yes, there's a planning division that reviews that. But it has to be an allowed conditional use. I mean, it is specified in the zoning law.
Okay. The other question I have is do we have an inventory of how many conditional permits that have not been satisfied at this time? Or is there like a database of that information? This question could be for Director Borja.
Not of the ones that have not complied. No, not of the ones that have complied. We do have a database of conditional uses authorized or approved, but we don't have a list of those that may not be in conformance with the conditions as set by the Guam Land Use Commission.
That information could be retrieved, correct?
Which one? The ones that do not meet or are not conforming to the conditions imposed by.
Yes, that have basically are still outstanding. So the conditional permit was given, but the project was the condition was never met. Is that retrievable information?
Not to my knowledge, no.
Okay, so we don't have an inventory of projects that have been approved conditionally and they did not satisfy their condition.
Correct.
Okay, that's definitely, I think this bill would definitely address that issue. And okay, thank you. That's all my questions, Madam Chair.
Thank you, Senator Perez. I've often thought of whether an audit needs to be done but knowing the personnel at Department of Land Management, I wouldn't impose that myself on them right now until we are able to address their staffing. But colleagues, we have one more person who has joined us to testify, Mr. Adrian Gogui. Mr. Gogui, you're recognized.
Thank you, Madam Speaker. This is my first time actually attending a public hearing via Zoom, so I'm not sure if my microphone is working.
Yes, we hear you loud and clear.
Okay. Thank you for the opportunity, and to all the other senators out there. And I see some of the GLOC members and agency directors out there. Okay, so I'm Adrian Gogui. I'm providing testimony as a private citizen. I'm also the vice chair for Safe Southern Guam Incorporated. If I could use the Pago Bay Resort project development as a basis for my testimony. First off, this bill is a great start for holding those accountable for those conditions that are listed in any GLUC notice of action and conditional approval for zone variances and the like. So if you're familiar with the Pago Bay Resort development, That development started in 2008. And all of the ARC agencies provided their feedback, which are captured in the notice of action. To this date, we don't know what are the statuses for those conditions that were imposed on that project when it was given the go-ahead. Subsequently, another variance was submitted in 2015 and was approved by the GLUC in May of 2016. It also listed a whole list of recommendations and terms and conditions for the project to move forward. Going back to 2008, 2016, and here we are starting off 2021. Who's being held accountable for enforcing those conditions? And in the end, we, the private citizens, the residents of the area, and ultimately the people of Guam are all impacted because a project was approved, the conditions were not met, and here we are many years later wondering what is the resolution to correcting this. I'll give you one very good example. The remains of our ancestors were unearthed as part of the survey for the 2008 project. And to this date, to our knowledge, those remains have not been interred. It was a condition going back to the 2008 approval. So again, in closing, I think this bill is a great start, Madam Speaker, for enforcing the conditions for any action that the Guam Land Use Commission approves. Thank you.
Thank you very much, Mr. Gogui. Did any of my colleague senators have any questions for Mr. Gogui? All right, if not, then there being no other persons to testify, I'm going to close on this bill, and I want to thank again Mr. Duenas, Mr. Gogui, Mr. Borja, Chairperson Enriquez, for testifying today and for your suggestions, recommendations. I very much appreciate those, as well as those of my colleagues. And I want to acknowledge that, you know, we have many developers and businesses who have complied with the conditions set by the GLUC, and that, you know, there are no problems with. However, there are examples of some that we are very, you know, aware that they have not complied with the conditions set by the Guam Land Use Commission. And we, you know, are trying to remedy that here by kind of appointing the Department of Land Management, since it is part of the building permit and certificate of occupancy permit process, to be another check as to whether those conditions or terms are being applied by this in the project, and also putting a little bit more towards the Department of Public Works to also ensure compliance when they are doing their permitting as well. You know, we have regulatory agencies in the application review committee who can enforce their, you know, the statutes and rules that are in place. But when it comes to enforcing conditions and terms that might have been set as part of the Guam Land Use Commission process, that's not been very clear whether they have that ability to enforce those. And of course, they can only even try to enforce the ones that have been approved by the Guam Land Use Commission. Many times they've made requests that are just not part of the conditions. So that's why we are, you know, in addition to those agencies, looking for the help of the Department of Land Management on behalf of the Guam Land Use Commission to enforce the terms and conditions that it sets. And so there being no additional individuals to present testimony, the committee will consider this bill duly heard. The time is now 12:33. Sidus Masi for your time and your attention to this. Thank you.